Welcome back to The Explainer. Today, we're jumping right into the incredibly complex architecture of India's national security laws. I mean, if you've ever wondered how the legal machinery of a massive state actually operates when the stakes are literally at their highest, well, stick around. Let's unpack this together.
It's kind of the ultimate paradox, isn't it? How does a democracy legally suspend civil liberties to protect its own survival? That is the core tension we're going to explore today. It's this high-wire, super delicate balancing act between keeping the state secure and protecting fundamental human freedoms, and we're going to see exactly how the law tries to manage that. So here's our roadmap for today. We'll be covering what security law actually is, constitutional emergency powers, the Union's duty under Article 355, the National Security Act, UAPA, and the bail bar, and finally, wrap it up with security versus civil liberties.
All right, let's get into Section 1. What is security law? The Pyramid Framework. Okay, let's dive into this. To really wrap our heads around national security law, we need a solid mental model. It's basically a tiered system, kind of like a giant pyramid. At the very broad base, you have constitutional powers. These are the ultimate, foundational authorities to act during massive emergencies. Then, as you move up the pyramid, you get into highly specific statutory frameworks. Those are the day-to-day tools used on the ground. Together, the whole system is designed to manage that crazy tension between security needs and executive power.
Moving on to Section 2, Constitutional Emergency Powers, focusing on Article 352.
So, at the very top of our constitutional pyramid sits Article 352. This is the ultimate break glass in case of emergency provision. And the evolution of this article? It tells a fascinating story about how democracies learn from the past. Back in 1975, the grounds for declaring an emergency relied on a pretty vague term, internal disturbance. But fast forward to 1978, and the 44th Amendment historically shifted that standard to something way stricter, armed rebellion. This wasn't an accident. It was a very calculated move to check executive overreach and make sure that immense power couldn't just be abused on a whim.
And because of those hard-learned historical lessons, the constitutional steps required to declare an emergency today are incredibly strict. You need the written advice of the cabinet, followed by a presidential declaration. And then, here's the kicker. It absolutely must be approved by a special majority in Parliament within just 1 month. When all that happens, it's a massive shift. India's quasi-federal structure essentially transforms, temporarily, into a highly unitary system to handle the crisis.
Next up, Section 3, Article 355, the Union's duty, which acts as the constitutional bridge.
If Article 352 is the ultimate emergency button, Article 355 is the crucial bridge that justifies the central government stepping into state affairs. It actually lays out a very specific threefold duty for the Union. They have to protect states against external aggression, protect them against internal disturbance, and ensure that state governance strictly follows the Constitution. In fact, in the landmark S.R. Bomai case back in 1994, the Supreme Court made it clear that the Union absolutely must exhaust these duties under Article 355 before taking the extreme step of imposing President's rule.
I really want to highlight Dr. B.R. Ambedkar's take on this. As the chief architect of the Constitution, he defended this concept by arguing that central intrusion into a state's domain is not arbitrary overreach. Rather, it is a solemn constitutional duty. I think that brilliantly illustrates how this power was intentionally designed to protect and maintain the constitutional framework, definitely not to destroy it.
All right, Section 4, the National Security Act and Preventive Detention.
Now, what's really interesting here is how we shift from those broad constitutional powers down into the specific everyday statutes. This is where the tension between state security and individual liberty gets very real. The beating heart of the National Security Act is preventive detention. This means a person can actually be detained without a trial and totally without a criminal conviction. It's based entirely on the apprehension, the fear that they might threaten public order or national security. It totally bypasses normal criminal procedures by relying on exceptions carved right into Article 22 of the Constitution.
But importantly, the law isn't just a blank check for the government. There are strict mechanics and constitutional safeguards built right in. For instance, detention under the NSA maxes out at 12 months. The detainee has to be informed of why they're being held as quickly as possible. And crucially, if they're going to be held beyond 3 months, an independent advisory board has to approve it. Though to be completely impartial here, it's worth noting that during those board proceedings, detainees don't actually have a statutory right to a lawyer. Which brings us to Section 5, UAPA and the bail bar, specifically Section 43D5.
The UAPA is India's main anti-terror law, and this brilliantly illustrates just how differently national security laws operate compared to ordinary ones. Think about normal criminal law. The standard is always bail is the rule, jail is the exception, right? A judge looks at the merits of the case before deciding. But under UAPA Section 43D5, that entire concept gets flipped on its head. The judge essentially has to accept the investigating agency's charge sheet at face value. If the allegations look prima facie or, true on the surface, bail absolutely must be denied. The accused can't even bring in outside evidence to defend themselves at the bail stage.
So how does this actually play out in the real world? Well, let's trace the Supreme Court's track record on this bail provision. Back in the 2019 Watali judgment, the court took a very rigid approach. They ruled that courts really can't dig into the merits of the case and just have to accept the state's allegations. But just 2 years later, in the 2021 K.A. Najib case, we saw a shift. The Supreme Court carved out this crucial constitutional relief, ruling that the strict bail bar doesn't totally erase a citizen's Article 21 rights, especially if they're facing prolonged time behind bars without a swift trial.
Finally, Section 6, Security versus Civil Liberties and Finding the Balance.
Trying to balance the survival of the state with the freedom of the individual is frankly the ultimate challenge. I want to share a really powerful thought from the Supreme Court in the 2023 Amina Begum case. The court explicitly stated that preventative detention laws are a colonial legacy with great potential for abuse and must be exercised sparingly. It's a vital reminder, right? The highest court in the land views these frameworks as extraordinary exceptions to democratic norms. They are absolutely not meant to be used as quick fixes for everyday law and order issues.
So we kind of end right back where we began, but hopefully with a much deeper understanding of the whole picture. Knowing this intricate, tiered framework, from the emergency powers in the Constitution all the way down to the strict bail bars of the UAPA, how can a democratic system ensure that laws built to help the state survive don't ultimately crush the civil liberties they're supposed to protect? It's a massive question, one that judges, lawmakers, and all of us have to constantly negotiate. I really hope this explainer gave you a solid foundation to explore this incredibly complex jurisprudence further. Keep questioning, keep learning, and thank you so much for joining me today.